National School. My lord, the parties are absent.
Appearance? Any appearance? Any appearance?
Yes, my lord.
Yes.
Ada Eze.
Ada Eze.
Yes, my lord.
Appearing for who?
Gozienwa Oha. Ada Eze.
Appearing for who?
Gozienwa Oha. Appearing for the claimants, my lord.
Yes, any other appearance? Any other appearance? This matter is for judgment. The judgment is ready.
As the court, please.
Yes, this is the judgment of the court.
As the court.
This judgment was initially slated to be delivered on 13th of April 2023. However, due to Easter court vacation, the matter has to come up today. The claimant commenced this action via originating summons filed on the 27th day of January 2021. With the leave of court, the originating summons was amended. The amended originating summons was filed on the 29th day of June 2022, wherein the claimant sought for determination of the following questions. They are: 1, considering the extent of the provisions of section 33 subsection 1, 39 subsection 1 sub A and B, 1, 2, and 3, section 40 subsection 1A and B, and section 73 of the Employee Compensation Act 2010, whether the dependent is an employer within the meaning of Employee Compensation Act 2010, and by so doing obligated to make a minimum monthly contribution of the sum of contribution of 1.0% of her total monthly payroll into the Employee Compensation Fund established under the Act and managed by the claimant. 2, if the answer to question 1 above is in the affirmative, does the dependent has an option whether or not to cause to be furnished to the claimant an estimate of her probable amount of her payroll, and whether or not to make a minimum monthly contribution of 1.0% of her total monthly payroll into the Employee Compensation Fund managed by the claimant. Having regard to the provisions of section 39, subsection 2 of the Employee Compensation Act 2010, where the dependent failed to cause to be punished to the claimant her estimate of probable amount of the defendant's payroll, whether the defendant is liable to pay as a penalty for the default a percentage of the assessment determined by the claimant, and the claimant may make its own estimate of the payroll, assess a levy on that estimate, and the dependent is bound by it. 4, if an employer within the meaning of Employee Compensation Act 2010 and considering the provisions of section 39 subsection 4 of the Employee Compensation Act 2010, where the dependent does not furnish complete and accurate particulars of her payroll to the claimants, or if the particulars of payroll are not true and accurate, the dependent, for every failure to comply and for every such particulars of the payroll, shall be liable to imprisonment or fine, or both imprisonment and fine. Having regard to the combined provisions of section 53 subsection 1 and 2, subsection 1, 2, 3, 4, 5, 6, and 7, and section 54 A, B, C, D, E, F, and G of the Employee Compensation Act 2010, whether an officer of the claimant or any person authorized thereby at any time and at a reasonable hours enter the dependent's workplace with or without warrant or notice and require the production of dependent payrolls and account record for inspection or examination of same with a view to ascertaining the accurateness of the dependent's payroll and assessing same. 6. If the question above are resolved in favor of the claimant, what order or orders is appropriate or deemed fit and necessary to make in the circumstances of this case. 7. Whether having regard to the combined provisions of Section 33, subsection 1, 39, subsection 1 of the Employee Compensation Act 2010, the claimant is entitled to be punished with the dependent estimate of probable amount of the dependent payroll from July 2011 up to date and is entitled to 1.0% of the dependent's total monthly payroll from September 2016 when the dependent becomes employer up to date. In anticipation of favorable consideration of the questions for determination, the claimant phrase for the following reliefs. They are: 1. A declaration that the dependent is an employer within the meaning of the Employee Compensation Act 2010 and by so doing obligated to make a minimum monthly contribution of 1.0% of the dependent total monthly payroll from July 2011 up to date and thereafter into the Employee Compensation Fund managed by the claimant. 2. A declaration that the dependent being an employer within the meaning of the Employee Compensation Act is obligated to cause to be furnished to the claimant complete and accurate particulars of the dependent total monthly payroll from July 2011 up to date and thereafter. 3. An order compelling the dependent to keep at all times with the claimant complete and accurate particulars of the dependent payroll from July 2011 up to date and thereafter. 4. An order compelling the dependent to compute or calculate and make a minimum monthly contribution of 1.0% of the total monthly payroll from July 2011 up to date and thereafter into the Employee Compensation Fund managed by the claimant. 5. An order granting entry of the claimant into the workplace of the dependent situated at number 10A, New Ikang Road, opposite Margaret Echo International Airport, Calabar Municipality, Cross River State, for purposes of inspection and examining dependent payroll and other documents necessary for assessment of dependent's minimum monthly contribution of 1.0% of the total monthly payroll from July 2011 up to date and thereafter. 6. An order compelling the dependent to grant officers of the claimant access to the dependent total monthly payrolls from July 2011 up to date and thereafter for purposes of assessing the dependent's minimum monthly contribution of 1.0% of the total monthly payroll from July 2011 up to date and thereafter. 7. An order directing the dependent to pay into the Employee Compensation Act Fund 40% of the total monthly payroll from July 2011 up to date as penalty for default in failing to cause to be furnished
My Lord, we are unable to hear you. We are unable to hear my Lord. It's like
I will continue from where I stopped. Number 7, an order directing the defendants to pay into the Employee Compensation Act Fund 40% of the total monthly payrolls from 2011 up to date as penalty for default in payment to punish the claimant complete and accurate total payroll from July 2011 up to date, and for failure to make minimum monthly contribution of 1.0% of the total monthly payroll. 10% interest on the dependent's total monthly payroll from July 2011 up to date. 9, the sum of 5 million naira cost of litigation. 10, and for such further or other orders as this honorable court may deem fit to make in the circumstances. The amended originating summons is supported by a 15-paragraph affidavit drawn to by Emmanuel Umika Ulai, a senior manager in the employ of the claimant. A 39-paragraph further and better affidavit was deposed to on 29th day of June 2022 by one Ifeoma Emokfai, legal officer with the claimant, in further support of the originating summons. However, the said further and better affidavit did not start with paragraph 1 to 15, which means the said further and better affidavit commence with number 16, paragraph 16 to 30, paragraph 16 to 39. Which is unusual way of numbering affidavit. Okereke Ezechi Esquire, counsel for the claimant, in arguing in favor of grant of the originating summons, relied on the depositions contained in the affidavit in support and the further and better affidavit. Counsel also adopted the addresses file along with the amended originating summons, as well as the written address file along with the further and better affidavit in support. In the written addresses file along with the originating summons and the further and better affidavit, 3 issues were formulated for determination. They are: 1, whether by construction of the extant provisions of section 33, 1, 39, 1 AB 123, section 40, subsection 1 AB 25 of the Employer Compensation Act 2010, the dependent is the employer and by so doing obligated to make minimum monthly contribution of 1.0% of his total monthly payroll from July 2011 up to date into the Employee Compensation Fund managed by the claimant, and cause to be punished to the claimant a complete and accurate estimate of the probable amount of the dependent payroll from July 2011 up to date. 2. Whether by construction of the extant provisions of Section 34, subsection 1, 2, A, B, and 3, and Section 36, subsection 1 and 2 of Employee Compensation Act, the claimant is entitled to and has a course of action against the dependent for the unpaid 1.0% minimum monthly contribution of the dependent total monthly payroll into Employee Compensation Fund for the period of July 2011 up to date. 3. Whether having regard to the provisions of Section 53, subsection 1, 2, and 3, 4, 5, 6, and 7, and Section 54 A, B, C, D, E, F, and G, the claimant or any of his officers or persons authorized thereby is entitled to at any time or at all reasonable hours enter into workplace of the dependent and have access to inspect and examine dependent payroll and other necessary documents with a view to ascertaining a proper assessment of contribution payable by the defendant. Counsel argued the three issues together, contending that they are both interwoven and close-knitted. Counsel answered the three issues in the affirmative. Counsel then refers to the provisions to be interpreted and the abandonment, and also refers to paragraphs 4 to 14 of the affidavit in support and paragraph 4 to 22 of the further and better affidavit, and submitted that the defendant operate with an employer name known as and called Marigold International School, and has operated as a business since 2002 with persons working for her under a contract of employment as teachers and administrative staff. It is submission of counsel that provisions of Section 73 of the Employee Compensation Act 2010, the defendant is for all purposes an employer under the Act. The defendant being an employer within the meaning of the Act is mandatorily required to make a minimum monthly contribution of 1.0% of her total monthly payroll into the Employee Compensation Fund established under Section 58, subsection 1 of the Employee Compensation Act 2010 and pursuant to the provisions of Section 33, subsection 1 of the Act as highlighted above. Counsel also submitted that it is the law as encapsulated in Section 39 and 40 of the Act that every employer shall cause to be punished to the claimant a complete, accurate estimate of probable amount of payroll of each of the employees industry within the scope of the Act. According to counsel, the claimant's affidavit evidence that the defendant is being in arrears of payment of contribution since September 2016, and several visits and demand having been made by the claimant to the defendant in respect of payment of contribution and submissions of total monthly payroll, but the defendant has willfully neglected to make the minimum monthly contribution and punish the claimant with his total monthly payroll, all in total breach of the provisions of the Employee Compensation Act. Counsel also contended that the officers of the claimant have consistently been refused entry into workplace of the defendant, and refused access to dependent payrolls and books of account for inspection in breach of the provisions of Section 53, 54 of the Employee Compensation. Counsel asked the court to resolve the issue for determination in favor of the claimant and grant the relief sought. It is submitted that the defendant, despite being served with the processes, willfully refused to enter appearance or file counter affidavit. Counsel submitted that failure of the defendant to file a counter affidavit amount to an admission of the abatements in the claimant's affidavit. In support of these submissions, counsel relied on the case of Zamfara State Government versus Greenwich Trust Limited, reported in 2019 LERR 49781, that where claim is for declaratory reliefs, such declaratory reliefs are not granted as mere admission or default of pleading. Council contended there is exception. Council submitted that the principle enunciated on declaratory reliefs is based on rules of court which do not make provisions for front-loading. With the involvement of front-loading in the rules of court now in operation in Nigeria, and the decision of the Supreme Court in G International Operation Nigeria Limited versus the Oil and Gas Services Limited, the application of the principle that declaration cannot be made in default or defense or admission applies to pleadings and not backed by witness statement on oath. According to counsel, in the case at hand, there is affidavit evidence which the defendant failed to respond and failed to enter appearance. To further buttress the point being made, counsel also refers to section 19A, B, and E of the National Industrial Code Act 2006, which gives power to the court to make necessary orders. Counsel asks the court to grant the reliefs, to grant the claimant reliefs as prayed. Court decision. I have carefully considered the originating process, commencing this suit, the further and better affidavit in support of the originating summons, In the originating summons, 7 questions were submitted for determination, and in anticipation of favorable resolution of the 7 questions, the claimant sought for 10 reliefs from the court, 2 of which were declaratory. A party activating the interpretative jurisdiction of the court as per originating summons, the claimant shall indicate as per of the court via originating summons, the claimant shall indicate with sufficient particularity the provisions or part of the document sought to be interpreted. Consequently, the rules of this court clearly envisage the originating summons must contain questions or questions of construction arising under the instrument involved and a declaration of right of a person interest. The declaration of right depend on the answers to the questions formulated for determination in the application by way of originating summons. A claimant intending to benefit from the time and effort-saving procedure of originating summons as in Order 3 of the National Industrial Code Civil Procedure Rules 2017 must therefore raise the question or questions for determinations on which he seeks the determination of court. This means the real issues placed before the court for adjudication are those raised in the originating summons, and those are the issues this court will have to address. Therefore, the choice of counsel for the claimant in this case to formulate 3 separate and distinct questions in the written submissions before the court, which he argued and which he stated to have been the question for determination in the originating summons, was wrong. This procedure adopted by counsel was not provided for in the rules. In the circumstances, I shall abide by the 7 questions contained in the originating summons as questions calling for resolution in this suit. Where an issue is not properly raised before the court, it has no business whatsoever to deal with it. A court must confine itself to the issues raised by the claimant in the originating summons. In the instant case, it was the questions and the accompanying reliefs or prayers that the claimant raised that embody the issues for determination in the action commenced by this originating summons. See the case of Shoboyede versus Minister of Lands and Housing. See also Obasanya versus Obafemi. In view of the foregoing, the formulation and argument on the 3 separate distinct issues by counsel for the claimant may be considered as abandonment of the originating summons, as no argument was canvassed on the 7 formulated questions contained in the originating summons. However, as this court duty is to resolve dispute on the questions submitted in the originating summons, the misconception of counsel in this suit may have stemmed out of the fact that all the arguments canvassed in respect of the 3 issues were based on the assumptions that the formulation of questions in the originating summons is akin to formulation of issues in brief of argument before the Court of Appeal. It is my view that the law governing formulation of issues from grounds of appeal is not the same with formulation of questions for determination in originating summons. Another reason why the wrong However, the three separate and distinct questions cannot affect the validity of the originating summons due to the fact that the written address in support of the originating summons has the same status with final written address in a suit contested by parties. This is because this court is a court of first instance and not an appellate court. The law is well settled that address of counsel are designed to assist the court to arrive at justice in a case when the facts are straightforward and in the main not in dispute. That's why court of first instance would be free to adjudicate First instance will be free to dispense with final written address. See Ogugua versus Jimo. In the case at hand, the claimant's decision to formulate 3 separate and distinct questions for determination will show that the claimant opted not to address the court on the questions formulated in the originating summons. This choice cannot in any way vitiate the originating summons. However, the court's business is to consider the questions formulated in the originating summons and not those 3 issues coined from the 7 issues submitted in the originating summons. In view of the nature of this case, the facts of which are straightforward, I am free to do away with the address of counsel. I shall now turn to the determination of the question formulated in the originating summons. From the questions submitted for resolution, the case of the claimant borders on interpretation of some provisions of the Employee Compensation Act 2010. The provisions are Section 32, subsection 1 ABC, 33, 34, 39, 40, 53, and 73. The defendant did not file formal memorandum of appearance before the court, but on the 14th day of December 2022, when this matter came up before the court, when Elder Enokam Essien, the chairman of PTA Marigold Secondary School, represented the defendant in court, and on 22nd day of March 2022, Emelda Umbotu Esquire, leading Mary Kathleen Bassi Esquire, appeared for the defendant. But in subsequent proceeding before the court, the defendant was not represented by any other person. Also, the counsel that once appeared before the defendant in court ceased to represent the defendant and failed to notify the court of the reason for not appearing again in the matter. In an action commenced by originating summons, the affidavit evidence takes the place of pleading. The abatements are not on oath. The abatements are on oath and have same evidential value as a witness statement on oath front-loaded in a suit commenced by a writ of summons in which pleadings are filed. The counter affidavit serves as a statement of defense. See the case of Ouru versus Adibu. See also Incorporated Trustees, the Assemblies of God Nigeria Limited versus the Assemblies of God Nigeria Limited. It is equally important to note that the defendant in this case failed and neglected to file any counter affidavit to contest or contradict the abatement contained in the claimant's affidavit before the court. Generally, in the absence of any counter affidavit to contradict or challenge or controvert the facts deposed in the affidavit of the claimant, the defendant will be deemed to have admitted those facts. In other words, the unchallenged facts in the claimant's affidavit should be accepted as conclusive evidence of the matter. The law requires the court to treat unchallenged and uncontroverted depositions of fact in an affidavit as duly established and proved, where proof as a matter of law is required. Where a counter affidavit was not filed to challenge the controverted deposition in the affidavit, the absence of counter affidavit is expressly and by presumption of law deemed to have admitted as to be true and correct all the contents of the deposition of fact contained in the affidavit in support of the originating summons. In the instant case, the failure of the defendant to file counter affidavit to the affidavit in support of the defendant's originating summons may mean that the defendant did not oppose the grant of reliefs. See the case of Oteju versus Magna Maritime. However, the law is settled that absence of a counter affidavit, however, there is exception to the above enunciated general principle of law on absence of counter affidavit. In law, absence of counter affidavit or opposition to the granting of relief sought does not automatically translate into success of originating summons or the claimant entitled to grant of the relief sought. This is because the exercise of a judicial discretion by the court is always required to be both judicial and judicious. The grant of relief sought in any action brought before a court of law involves the exercise of the duty and judicial discretion of the court. Therefore, originating summons is not granted merely on ground of absence of a counter affidavit to challenge or controvert the abatements in the affidavit in support. An action is to succeed or fail, as the case may be, on the strength of the materials disclosed and deposed to in the affidavit filed in support of the reliefs, which the court has a duty to consider and be satisfied that it is grantable. See the case of Ujamu versus Olopimilahi. The court has also power to appraise the deposition in the affidavit and to decide on their merit, even if no counter affidavit was filed against the affidavit. See the case Nwabuko versus Oti. See also Alagbe versus Abimbola. Also, where affidavit evidence on the face of it is self-contradictory and no explanation is given for the contradiction, the court must discountenance it, notwithstanding that it is not challenged by a counter affidavit. See the case of REAM versus Aswani Textile. See also Ocho versus Ojo. The brief facts that warranted the filing of this suit, as can be gleaned from the affidavit in support of the further and better affidavit in support of the originating summons, are that The defendant is one of the employers of labor in Calabar, has been in the business operating nursery, primary, and administrative staff who have been receiving salaries from the defendant since the introduction of the Employee Compensation Act compensation scheme set up by the Employees Compensation Act 2010. The defendant has failed and willfully neglected to furnish the claimant with dependent complete and accurate total monthly payroll from July 2011 to date, and failed to make a minimum monthly contribution of 1.0% of the dependent's total monthly payroll into the Employee Compensation Fund managed by the claimant. This is despite formal handing over of to the defendant by the officers of the claimant of forms which the defendant is to fill are returned for the purpose of assessment. It was also stated that inspection officers of the claimant have severally visited the defendant to solicit for access to examine defendant's payroll from July 2011 up to date with a view to assessing defendant out of the appropriate 1% of minimum monthly salary payroll contribution. But the defendant has consistently refused the officers entry into her workplace and access to her payroll. It was also averred that following the default by the defendant to punish the claimant with a complete and accurate payroll from July 2011 to date, the claimant has imposed a penalty of 40% on the dependent total in monthly payroll from July 2011 to date. The claimant equally imposed interest of 10% on the dependent monthly payroll from July 2011 to date. In another abatement, the dependent was said to be employer having contracted some persons as staff of the defendant's clinic, maternity and laboratory sciences. It is apt at this juncture to reproduce the provisions of Employee Compensation Act submitted for interpretations. They are, I shall skip reading the provisions. Council will read when they collect. I have reproduced the relevant provisions verbatim. I have deeply considered the above quoted provisions of the Employee Compensation Act submitted for interpretation by the originating summons under consideration. When these provisions are juxtaposed with the 7 questions formulated by the claimant and the reliefs being sought as per the originating summons, it will be apparent that the claimant is praying for the court to declare that the dependent as employer is an employer as per the provisions of Employee Compensation Act 2010, are liable to punish the claimant with complete and accurate particulars of defendant's monthly payroll from July 2011 to date and thereafter. The claimant is also seeking for order directing the defendant to compute, calculate, and make a minimum monthly contribution of 1.0% of its monthly payroll from July 2011 to date, and thereafter into Employee Compensation Fund managed by the defendant. There is also a request for granting of officers of the claimant access to the dependent workplace for purposes of inspection and examining of the dependent monthly payroll and other documents necessary for assessment of dependent's monthly contributions of 1.0% of the total monthly payroll from July 2011 to date and thereafter. There are also requests for orders for payment of 40% penalty, 10% interest and cost of this suit. The provisions of the statute sought to be interpreted in the originating summons are very clear and unambiguous. The law is right when a court is faced with an interpretation of statute which is unambiguous and clear, the court should give the provisions literal meaning or interpretation. See the case of Pawami versus IGP. See also African newspaper, Nigeria versus FRN. See also Nigerian Army versus Abu. The law demands of statute that will lead to an absurd result. This is because absurd results are presumed to be intended by the draft lawmakers. See the case of INEC versus Yusuf. See also GCM Limited versus Travelers Palace Hotel. See also Dominic Nigeria Limited versus Utu. Therefore, clear and unambiguous provisions of statute must be given their ordinary grammatical meaning. The primary concern of the court when faced with interpretation of statute is the attainment or ascertainment of the intentions of the legislature by examining the language used therein. Where the language used in the legislation or statute or constitution is clear, explicit, and unambiguous, the court must give effect to it, as the words used speaks for themselves. The basic canon of interpretation are that words and phrases must be given their basic ordinary grammatical meaning. In other words, the generally accepted rule of construction is that it is to be assumed that the words and phrases of technical legislations are used in their technical meaning if they have acquired one and otherwise in their ordinary meaning. Phrases and sentences are to be construed according to the rules of grammar. If there is nothing to modify, alter, or qualify the language which the statute contains, must be construed in the ordinary and natural meaning of the words and sentences. This approach is regarded as literal interpretation or characterized as a positivist approach. See the case of Amechi versus INEC. See also Nigerian Army versus Abu Supra. See also of Buoji versus Umahi. The court is equally enjoined to consider statutory enactment together and construe them as a whole, not in isolation or in piecemeal. Whenever a court is faced with the interpretation of statutory provision, the statute must be read as a whole in determining the object of a particular provisions. Thus, all provisions of the statute must be read together and construed together unless there is a very clear reason why a particular provision of the statute should be read independently. To achieve a harmonious result, a section must be read against the background of another to which it relates. This principle is indispensable in giving effect to the rule intention of the lawmakers. In the instant case, to ascertain the intention of the lawmaker, the sections of the law and the entire provisions of the Employee Compensation Act must be read together, not in isolation. See Yabuge versus Commissioner of Police, see Bello versus Attorney General of Oyo State, see Nobis Elendu versus INEC, see also APC versus ISAID. There are specifically three main rules of interpretation. The literal, which states that where words are plain and unambiguous, they must be given their natural, ordinary meaning. Unless to do so will lead to absurdity or do violence to the provisions of the statute. That is, the plain words used by the legislature must be given their ordinary meaning. See Adewumi versus AG Ekiti State, see AG Lagos State versus Eko Hotels, see Ojo Kolobo versus Alamu, see Sani versus President FRN. The golden rule, which states that where the use of the literal rule would lead to absurdity, repugnance, or inconsistency with the rest of the statute, the ordinary sense of the word may be modified so as to avoid absurdity or inconsistency, but no further. See the case of General Cotton Mill Limited versus Travelers Palace Hotel. See also Umer No versus Anekwe. In this case, the provisions of the statute to be interpreted, Employee Compensation Act, are clear and unambiguous. The duty of the court will be limited to construing the clear provisions by giving the plain words their natural and ordinary interpretation, since it is evident that the statutory language and legislative intent are clear, plain, and unambiguous. See Ameti versus INEC. See Aromolaron versus Agoro. Their interpretation of the provisions literal interpretation of the provisions of the sections of the law to be interpreted must be adopted. It is in line with the above enunciated principles of interpretation of the statute that this court will be guided in determining the questions and relief sought by the claimant. A holistic perusal of the entire provisions of the Employee Compensation Act will reveal that the act was enacted for purpose of ensuring a guaranteed fair compensation scheme for employees or their dependents as a form of social security in line with current global best practices. See Section 1 of the Employee Compensation Act. The Act provides an open and fair system of guaranteed and adequate compensation for all employees or their dependents for any death, injury, disease, or disability arising out of or in the course of employment. It also provides rehabilitation to employees with work-related disabilities, provide fair and adequate assessment of employers. The Employee Compensation Act seeks to provide a quick and simplified procedure of course of action to compensate employees for workplace injuries or disability as a fair alternative to common law action in damages. As distinct from alternative common law action against relevant employee and against relevant employer, the claim for compensation under the Act is against the Employee Compensation Fund, established pursuant to Section 56 of the Employee Compensation Act. The compensation is payable on a no-fault basis. Once the employee is injury, occupational disease, or disability is one arising out of and in the course of its employment. Again, under the Act, the specific sum of payable as compensation is determined by a predetermined schedule or formula and with a ceiling on the financial liability of the fund, which is not related to the financial contribution of the employer. So it is in the mode of insurance scheme, and the fund is actually managed by the claimant in this case. With the coming into force of the Employee Compensation Act, the compensation payable from the Employees' Compensation Fund is statutorily guaranteed. As pointed out earlier in this judgment, the compensation is a form of social insurance scheme, simplified by the employee's obligation to contribute a fixed percentage, employer's obligation to contribute to a fixed percentage of its total monthly payroll, or an assessment based on certain risk factors, and its total monthly payroll to the fund by the Section 56 of Section 2 of the Employee Compensation Act, employee is not required to contribute a dime. So the contributors to the fund are, and the funders of the fund are employers, take up grant from federal government, proceed of investment of the fund, gifts and grants from any national or international organization. The employer's liability under the ECA comprises of monthly contributions to the fund, ostensibly a sort of insurance premium against any bodily injury, disease or occupational disease to its employee arising out of or in the course of employment. See section 30, by section 33 subsection 1 of the Employee Compensation Act. It requires that every employer within the first 2 years of commencement of the act make a minimum monthly contribution of 1.0% of the total monthly payroll into the fund. The contribution is a transitory and compulsory contribution pending the assessment of the actual risk factor of a relevant employer. Thereafter, the board, that is the defendant in this case, shall from time to time make a regulation prescribes the categorization of risk factors of each class or subclass of industry sector or workplace and the amount contribution to be made into the fund. See section 35(1) of the Employee Compensation Act. A payment of assessment shall be due to the first of January in the year for which it relates. Section 33, subsection 2 provides the different assessment rate applicable to each class and subclass of industry, sector, or workplace. Following the categorization, the board shall assess employers for such sum in such manner from the procedure as the board may, from time to time, determine based upon estimate of the employee's payroll or relevant year, or determined by the board. See section 34, subsection 1 and 2, and may be by order establish a minimum assessment. See section 34 and 36 to ensure compliance with the provisions or assessment and contributions of employers. By section 36 subsection 1, the board shall have course of action for any unpaid assessment. By section 49 subsection 1 A and B, the employee is to at all times at some place in Nigeria keep complete and accurate particulars of the employer's payroll. The employer is to cause to be furnished to the claimant when the employer becomes employee and provide signed reports of the payroll of the dependent, not later than 31st day of December 2022. Not later than 31st December in each year or at such other time and in the manner required by the board, failing which the employer, that is the defendant in this case, shall be liable to pay penalty for a default, a percentage of the assessment prescribed by regulations or determined by the board. And the board may make its own estimate of the payroll, assess and levy on that estimate, and the employee is bound by it. By the section 40, subsection 1, A, B, C, the dependent shall not, later than last day of February in each year, or at such a time as may be required by the board, issue statement of the total amount of all earnings paid to each employees in the preceding year and estimating the earnings that will be paid to each employee in the current year or any part of it as directed by the board. and any statement found to be incorrect, the board shall reassess the employer for each year that the statement was incorrectly made, and may charge the employer interest at a rate determined by the decision of the board on any assessment that was not paid. The dependent is required to declare earnings and earnings of an employee who would be entitled to consequential. The dependent is required to declare earnings of the employee, earning of an employee who would be entitled to compensation. Under Section 49, where employer is engages in an industry within the scope of this act and has not been assessed in respect of it, the dependents, if it considers that the industry is to carry on business temporarily, may require the employer to pay or to give security for the payment of the fund of a sum sufficient to pay the assessment for which the employer may be liable if and by Section 52, every employer is required to keep accurate account of all remuneration paid to its employee. By Section 53, the board may authorize any person to examine the books and accounts of the employer. By Section 54, an officer and in Section 73, the term employer was defined to include any individual, body, corporate, federal, state, or local government, or any government agencies who has entered into a contract of employment to employ any person as an employee or apprentice. As noted earlier, the crux of the facts supplied in the affidavit in support of the originating summons and further and better affidavit are that the defendant was said to have been in business of nursery and primary school since 2002 and has failed and refused and neglected to make payment of 1.0% of its annual payroll, or that the refusal of the defendant to allow the claimant access to workplace and payroll, the claimant has been unable to ascertain the actual number of dependents employee, the payroll, and actual sums equal to 1.0% of the total monthly payroll due to the default of the dependent in punishing the claimant with the complete and accurate record from July 2011 up to date, despite repeated visit and demand by the officers of the claimant. The claimant has exercised her power under the law and imposed penalty against the claimant, against the dependent. I have assiduously examined the facts as revealed by the affidavit in support, the further and better affidavit in support, and the provisions of Employee Compensation Act contained in the originating summons for interpretation, as well as entire provisions of the Employee Compensation Act. It is correct, having regard to the foregoing exposition of the facts and the law to be interpreted, that the claimant has in paragraph 5, 6, 7, and 8 of the affidavit in support and paragraphs 25, 26, 27, of the father and better affidavit in support of the originating summons stated that the dependent is one of the lawyers is one of the employers in Calabar who had since 2002 been in business of nursery, primary, and secondary schools. It is correct, having regard to the foregoing exposition, paragraphs 5, 6, 7 of the affidavit in support, paragraphs 25, 26, 27 of the further affidavit, where the dependent was said to be employer and into business of nursery and primary school. Therefore, by virtue of the definition of term employer as contained in section 73 of the Employee Compensation Act, the dependent in this case is an employer within the meaning of the ECA. The dependent being employer as per ECA is duty bound pursuant to section 33 is duty bound pursuant to section 33(1) of the ECA to, within the first 2 years of commencement of the Act, make a minimum of monthly contribution of 1.0% of the total monthly payroll into the Employee Compensation Fund, as noted earlier in this judgment. This payment, though made compulsory by the law, it is temporary pending the assessment of the actual risk factors of the relevant employer, in this case, the dependent. Thereafter, the dependent is under the duty from time to time to make regulations prescribing the categorization of risk factors of each class or subclass of industry sector or workplace, and the amount of contribution to be made into the Employee Compensation Fund. It is after the categorization that the claimant shall assess the dependent for such sums in such manner from the procedure as the claimant may from time to time from the facts as revealed by the affidavit evidence before the court. The dependent has not been shown to have made within the first 2 years of commencement of ECA made any payment of 1.0% of the dependent total monthly payroll into the Employee Compensation Fund established pursuant to section 56 of the ECA. There is equally no evidence adduced by the claimant showing that the dependent has been assessed for payment of the contribution into the Employee Compensation Fund by the claimant as required by law. There is also no evidence before the court to show that the dependent has failed or neglected to pay any amount assessed by the claimant in line with the extant provisions of ECA. It is also clear from the evidence before the court that the dependent has refused to allow officers of the claimant to have access to the dependent's workplace and payroll for purposes of examining and assessing the amount payable to the dependent and contribution There is also no evidence before the court to show that the defendant has failed or neglected to pay any amount assessed by the claimant in line with the extant provisions of the ECA. It is also clear from the evidence before the court that the defendant has refused to allow officers of the claimant to have access to the defendant workplace and payroll for the purpose of examining and assessing the amount payable by the defendant as contribution to employee compensation fund. There is also no evidence to show that the claimant has exercised his power under Section 41 and 43 of the ECA in relation to assessment of what amount is payable by the defendant to the employee compensation fund as the defendant's contributions. In view of the foregoing revelation, the claimant has partially proved entitlement to some of the reliefs being sought and has failed in some other respects. In view of the foregoing, my findings is as follows. On relief 14A, the declaration is hereby granted in favor of claimant that the defendant is an employer within the meaning of Section 73 of the Employee Compensation Act and is liable to, within 1 to 2 years of commencement of Employee Compensation Act, make a minimum payment of 1.0% of the total payroll of the dependent into Employee Compensation Fund. Or relief. A declaration is hereby made in favor of the dependent, in favor of the claimant, that the dependent, being an employer, is statutorily obligated, mandated to keep complete and accurate record of particulars of its total monthly payroll from July up to date. The dependent is hereby ordered to align with Section 39(1) of ECA to keep at all times with the claimant complete and accurate particulars of dependent's payroll from July 2019 up to date and thereafter. This relief is not grantable Relief 14D is not grantable because it is vague. The claim being monetary in nature need to be specifically pleaded and strictly proved. Since the amount is not known, the relief fails the test of proof for special damages. Furthermore, there has been no any assessment tendered before the court made by the claimant due to refusal of the defendant to pay payment as required by Section 33, subsection 1. Relief 14E succeed. An order is hereby granted, ordering defendant to grant officers of the claimant access into defendant workplace situated at number 11 Obame Equia Street, Leopard Town, Calabar Municipality, Cross River State, for purposes of inspection and examination of dependent payrolls and other necessary documents for assessment of dependents' minimum monthly contribution into Employee Compensation Act 2010. Relief 14F, this is a duplicate of Relief 14E. Relief 14G is not grantable as it is vague, as there was no assessment base on which penalty was imposed. Relief 14H is not grantable as there is no quantum base on which interest was charged. It is to be noted that Reliefs 14 D, F, G, and H could not be granted because they are monetary in nature, which by law they are special damages claim, requiring to be specifically pleaded and strictly proved by cogent, compelling, and sufficient evidence. Strictly proved by cogent, compelling, and sufficient evidence. These reliefs being claimed for special damages must be claimed specifically and proved strictly. The facts of its appear to be admitted does not relieve the party claiming it of the requirement of proof. It's compelling evidence. See NNPC versus Filippo. See also Ignatius Anyao. In the case at hand, the claimant did not specifically plead and specially did not plead the special damages, but there is no specific amount claimed and there is no strict proof of the special damages claimed. The law has always been that a party must succeed or fail on the strength of his or her case as presented before the court. It is well known principle of law that special damages claimed by a party the law has always been that a party must succeed or fail on the strength of his case. See Dumes versus Ogboli, see Agwangwa versus Onuokwe. Whenever special damages are claimed, the party so claimant has the appeal tax of a strict proof. In effect, the rule requires anyone asking for special damage to prove strictly that he suffered the special damages as he claimed. Thus, the claimant should establish the entitlement to that type of damages by credible evidence of such character and would suggest that he is indeed entitled to an award under the said head. The general law of evidence as to prove of, by preponderance in civil cases operate in discharging such burden of proof. In the instant case, the claimant failed to prove special damages. The failure to particularize and strictly prove the special damages by qualitative and credible evidence renders the claim for special damages liable to be dismissed. The law is well settled that for a party to be awarded any relief, the court of law that party must not only plead such particular must not plead with particularity, but also proof of credible and convincing evidence that is indeed entitled to the relief it seeks. The court of law has no jurisdiction to grant or pray that which is It is pertinent to stress that the claimant, in making the special damages claim, failed to show that there has been assessment on what the defendant is to pay, which the defendant refused to honor or settle. These four reliefs must fail since the claim is a species of special damages, which must be specifically pleaded and strictly proved. This is not done by the claimant in the instant case. See NNPC versus Kilipo Supra, where the Supreme Court applied aptly held that by special damages are never inferred. The fact that it appears to be admitted does not relieve the party claiming it of requirement of proof with compelling evidence as special damages are exceptional in character, and so there is no room for inference by court. It is unreasonable to consider a claim for special damages reasonable in the absence of proof. A claim for special damages succeeds on compelling evidence to justify it, and not on the same claim appearing reasonable to the court or on admission. See Mr. Ignatius Anyao versus Aloysius Uzo. For avoidance of doubt, before concluding this judgment, let me say that this case has brought out the problem related has brought out clearly the problem related to copy and paste. Which is now very common commonly practiced by people using computers, including men in the legal profession, consequently, there is need for counsel to be very circumspect while preparing processes for filing in court in order to avoid falling into the pitfalls of copy and paste. For avoidance of doubt, the order of the court is as follows. 1. A declaration is hereby granted in favor of the claimant that the defendant is an employee within the meaning of provisions of Section 73 of the Employee Compensation Act 2010 and is liable to, within the first 2 years of commencement of Employee Compensation Act, make a minimum payment of 1.0% of the total monthly payroll of the defendant and into the Employee Compensation Fund established under Section 56 of the ECA. 2. The defendant is hereby ordered to make payment of 1.0% of its total monthly payroll within the 2 years of commencement of Employee Compensation Act 2010 into the Employee Compensation Fund established pursuant to Section 56 of the Employee Compensation Act 2010. 3. A declaration is hereby granted in favor of the claimant that the defendant, being an employer, is statutorily obligated, mandated to keep complete and accurate record of particulars of its total monthly payroll from July 2011 up to date and thereafter. 4. The defendant is hereby ordered to, in line with Section 39 of Section 1 of the ECA, to keep all at all times with the claimant complete and accurate particulars of the defendant's payroll from July 2011 up to date and thereafter. 5. An order is hereby granted ordering the defendant to grant officers of the claimant access into the defendant workplace situated at number 14 Obame Ikoy Street, Leopard Town, Calabar Municipality, Cross River State, for purposes of inspection and examination of the defendant payroll and other necessary documents for assessment of the dependent minimum monthly contribution into the Employee Compensation Act 2010 and from July 2011 to date and thereafter. 6. The claimant is entitled to cost in the sum of 500,000 naira. The defendant is hereby ordered to pay the claimant the sum of 500,000 naira cost of this suit. The judgment is entered accordingly.
As the court pleases.
As the court pleases.
Yes.
We must God grant more wisdom. Thank you, my Lord.
Yes. Okay. You're welcome. Registrar, any other matter?
No, my Lord. No, my Lord. That's all for today.
Okay. Thank you very much, Counsel, for joining.
Thank you, my Lord.
You're welcome, my Lord.
The administrator, you can end the sitting.
All right,
Thank you
my
very
Lord.
much.
Take care of yourself. Take care of